grab a mug of water and
Good evening, everyone. Welcome to our webinar on Framework for Judicial Data Regulation, Balancing Open Courts and Privacy. I am Akanksha and I work as a research associate at Daksh. Daksh is a civil society organization which undertakes research and activities to promote accountability and better governance in India. Now, integral to the rule of law, we, on the one hand, have a long-standing constitutional principle as well as a common law tradition of open courts, which is that court proceedings are open to the public and judgments of the court are widely published. Conversely, court proceedings also have a lot of sensitive private information and confidential information that may present problems for privacy or other data security issues. How do we square off the need for disclosure to ensure transparency with these privacy concerns and other countervailing interests? And this is especially concerning in the digital age when public documents are freely available online. In today's webinar, we will begin with a short presentation on this topic, followed by a discussion with our esteemed panelists, Dr. Natalie Byram, Mr. Pranesh Prakash, and Mr. Jaideep Reddy, on the various mechanisms which are available to address the tension between balancing open courts and privacy. Let me take this opportunity to introduce our panelists for the day. Dr. Natalie Byram, she is the Director of Research and Learning at the Legal Education Foundation, where she leads their work on the Smarter Justice program. She's a part of the BBC Expert Women Network and sits on the Administrative Justice Council. And she has been seconded to the United Kingdom's Her Majesty's Courts and Tribunal Service as an expert advisor on open data and academic engagement. And recently, she has led a rapid consultation on the Civil Justice Council, which aimed to explore the impact of COVID-19 on the civil justice system in the United Kingdom. Mr. Pranesh Prakash, he is an affiliated fellow at the Yale School's Information Society project. He was a 2019 India-US Public Interest Technology Fellow at New America and was he was a member of the founding team at the Center for Internet and Society, which is a nonprofit organization that undertakes interdisciplinary research on internet and digital technologies and their implications on the legal system. His work is focused on promoting and engaging with policymakers on the areas of access to knowledge, openness, including open government data, open standards, open source software, and open access, freedom of expression, privacy, and internet governance. Our third panelist is Mr. Jaideep Reddy. He's a dual qualified technology lawyer, and he's licensed to practice in India as well as California. He's presently working at Nishit Desai Associates, and his practice focuses on disruptive technologies and how they intersect with the law. He advises leading businesses on issues of privacy, cybersecurity, blockchain, and he also takes a keen interest in how technology can be used to improve access to justice and improve the legal system. If you have any questions for our panelists, please feel free to put those in the chat box, and we'll get to those at the end of the discussion. Now, moving on to the presentation. So judicial data in India remains at the confluence of two currents. The first current is the need for openness. This ensures transparency in the judicial system because this allows the public to, it allows essentially a window into the functioning of the courts and thus allows public to understand how the judiciary is functioning. The other current is privacy. This is because court records contain a lot of private information, which are now available online in the form of judgments, etc. But before we embark on trying to balance these two currents, it is very important to understand certain characteristics of the judiciary which are very unique to it. The first is the independence of judiciary is in all its action. The second is the concept of open courts, which requires that all court proceedings be held in full public view. The third is about the judicial process and how it relates to data. So the information which is provided to the judiciary for its judicial making function is either submitted voluntarily by the parties or is acquired as part of the due process requirements. On the other hand, privacy in India, it has recently been recognized as a fundamental right. The other important point to note is that none of these two rights, that is, open courts or privacy, is an absolute right. And there are certain limitations which can operate upon both of them. Recently, the Indian government has introduced two bills on data regulation, the personal data regulation and the non-personal data. The PDP bill, it exempts judiciary from the provisions of the Act as far as judicial functions are concerned. And the non-personal data framework, it mostly revolves around the economic value of non-personal data. And hence, both these are insufficient to address the privacy concern arising out of court records. Now, when we talk of judicial data, it can encompass a wide range of data. So judicial data covers not only court records, but also data generated by further processing of these court records, for example, as done by law journals or commercial legal databases. Court records further, they can be of the nature of a case record pertaining to a particular case, or they can be in the nature of administrative records. And all these records have different types of personal information contained in them. Moving on, how has online access changed anything? So earlier, in order to address court records, we had to physically travel to the courtrooms or make an application before the registrar to gain access to court records. Right now, some of these court records have moved online and can easily be accessed with a few clicks on the internet. This has led to the loss of practical obscurity. So earlier, when we had to travel, it required an investment of time and money, which ensured that only those people with a legitimate interest in court records were gaining access to these records. However, now it is available to anyone, anywhere with a few clicks of a button. And this has led to a lot of privacy concerns. The other effect is on the effect of time on these records. Earlier, certain records would just naturally fade away from our memory. But now, with these records being available online, a simple search can throw up these information which were long buried. And this has implications on things like the right to be forgotten or on rehabilitation of offenders. And lastly, whatever information is available online out of the court records, these information can be combined with other sources of publicly available information to gain deeper insights into a person. This has led to risks such as identity theft, fraud, harassment, profiling, and other such issues. As we discussed earlier, the right to privacy has both a negative and a positive component. The positive component requires the state to form a data protection framework. However, our current data protection legislations give an exception to judicial functions, which is why the judiciary has to come up with its own framework to regulate judicial data. At present, the judiciary is maintaining this balance between open courts and privacy by using certain mechanisms such as in-camera proceedings or prohibiting or restricting the reporting of proceedings. However, as we move more to the online records, this balance is kind of changed and new methods have to be employed to take care that both open courts and privacy are preserved. So the general principles of data protection provide a good starting ground for the judiciary to formulate its own policy. However, it is true that the general data protection principles cannot blindly be applied in the judicial context because of its peculiarities, such as independence of the judiciary and the need to follow due process, which is why the data protection principles will have to be adjusted to a certain level to take care of these uh, unique concerns of the judicial context. Some factors which can help us in regulating access to data in the digital age are the sensitivity of data, the volume and the level in which that data is sought, who is seeking access to the data, whether it's a party to the proceeding, an academician, a media reporter. So the access can be varied depending on who is asking for such information. And another factor which could be important is the timing of access. Therefore, there is a need to map the sensitivity of data elements across the judicial process and see whether the disclosure of such element outweighs the privacy concern that a person might have regarding such disclosure. As I said, the judiciary will have to make its own framework to govern judicial data. And depending on the level of maturity of the digitization in the Indian judiciary, the regulatory body can also move and have more powers to regulate the judicial data. The regulatory body can resolve disputes, it can establish standards and protocols, it will need to train judges, court, and staff on the privacy framework that it formulates. It will have to conduct audits on compliance, and it should also liaise with the general data protection regulator to keep abreast with the latest developments in the privacy domain. So the recommendation would be to appoint a body to undertake a full um, to understand the current legal framework and to understand what are the privacy concerns that arise in a digital age. It will have to undertake extensive consultation with all stakeholders because any policy for privacy or access will have to take care of the exact needs and concerns of the various stakeholders involved in the judicial process. For this, an extensive data mapping exercise has to be carried out. Then a draft regulation can be formed and a privacy baseline can be set from which certain derogations would be possible depending on the various factors to regulate access, such as timing, sensitivity, etc. There is also a need to make regulatory and technical changes in the system, which is currently prevalent. And then lastly, the privacy concerns should feature in the information management systems of the judiciary from the very beginning so that these systems can address this concern without uh, the need for revisiting and changing the system to in the future. So with that, we are now ready to move to our discussion with our panelists. So as an opening remark, I would request all three panelists to let me know their views on what does open justice or open courts mean in this digital age. Has the technology led to a transformation in the way we understand open justice today? So maybe we can start with Dr. Natalie and then move on to Pranesh and Jaideep.
Thank you so much, and thank you so much for that brilliant and really thoughtful presentation. I have to say a lot of what you set out there really accords with some of the challenges that we're facing in England and Wales, and I really commend the work that you and your organisation have done to pull that together. I think really one of the all of the issues that you've identified around the reduction in practical obscurity, around the way in which the digitisation of justice reduces the types of friction in the system around accessing data that was used to typically manage or balance privacy versus openness concerns are really very live questions. I think the digitization really prompts us all to really go back to first principles and think about what it is that open justice is meant to deliver. Like, what does it mean? So historically, that's been open justice has been achieved through people going and sitting in courts. But really, if you look certainly in England and Wales law, it's designed to promote accountability. So that's accountability of two kinds. It's to be able to understand whether judges are applying the law correctly to cases. And it's also to be able to understand really how, particularly where cases involve the state versus individuals, to be able to understand whether the state is adhering to its obligations. It also exists to help the public to really understand what happens in court and understand how the law operates in practice, and therefore lobby the state or the legislature to change it. And so I think really moving forward, we need to think about the different ways in which you might achieve that, whether that is providing better aggregate data about what happens in courts to enable you to understand sort of trends and the way in which different groups' interests and rights are being met, or whether it's about actually sort of thinking about how we can use technology to provide wider access to what happens in courtrooms. But I really think it's important that we do go back to those first principles and think very clearly, okay, what is open justice meant to achieve? And then how can we use data and technology to be able to deliver that going forward?
Thank you, Natalie. Pranesh, would you go next?
Absolutely. So again, thank you very much for having me on, and that was an excellent presentation, and two papers that you put out are excellent as well. Very thoughtful, and I think people would should really read those and would gain a lot by reading them. I'd like to second many things that you've laid out in the paper and what Dr. Byram just said as well, that this shift to digital technologies and digitization that has happened, and that is happening even more now thanks to the pandemic, really forces us to look at first principles and to consider the relevance of things that have evolved organically over time, and in some cases have been embodied in law, but also how they match up or how they actually work in practice when it comes to loss of practical obscurity and so on, which have not really been thought through. So digitization that's happened so far in the judiciary has just happened by itself. There hasn't been careful thinking through of how to apply these principles, how to approach this from a principled perspective. Now, apart from ideas of accountability not having, say, a star chamber kind of atmosphere, there are many other reasons for open justice as well. In a common law system, the precedential value of previous cases and ability to have them and to cite them, research needs to see whether the judicial system is serving everyone equally, and apart from that, even to inform public opinion, what court reporters do. Okay, we see with the increase in legal reporting in the last, say, 3 or 4 years in India, the amount of space that court discussions take up in public opinion, it's really increased. We're talking far more about courts now in India than I would say we did around 10 years ago. And also easier access to justice, right? It's important for litigants as well to have open justice, to know how their cases are proceeding, to be able to look up a case file online to track where it's at and so on. Not just to have to rely always on their lawyers to do this and so forth. So there are a wide variety of reasons. I think the question really at the heart of this is whether one has to support an open by default system or a privacy by default system. I think that people who think we can have both by default, in a sense, we're really kidding ourselves. A system really has to embody one principle or the other as the default and the other as the exception. And that's the way, of course, you have to give weight to both, and you have to seek to balance, though very many human rights advocates hate the word balance, but I will use it still. You have to try to balance both values, but it's only one that you can have really by default, and the other will need to necessarily be the exception. Now, if you go through, for instance, if you look at the flow chart that you provided, thinking in terms of whether something is sensitive, and the next slide, the assumption there is around that the default is privacy, that you start off by questioning whether it's sensitive and so on, and then you see whether most of the roads lead to actually being data protection should apply. This should remain private, and then a few in just one or two, I think of the various options will finally lead you to this is public information. And so there's that value is embedded in how you structure this question, and these questions that you have to go through, how you structure the flow chart. These values themselves are embedded, I'd say, in them. So that's something to keep in mind. I'm happy to come back to more detailed issues around questions of data protection, the role consent plays on how we think about privacy when it comes to, say, the judiciary, because I would argue that there is no right or wrong answer in this, and I'd like to kind of explain that in some amount of detail, to go through how we need to not just the matrix that you've constructed, I think is beautiful, the matrix around granularity of control and amount of control, but one thing that's missing there is time, because temporal aspects also matter. There might be, say, a presumption that after 15 years, these things are no longer relevant, or after 20 years, or after a prisoner has served their sentence. And one can think of various examples like that. But time is also an important element. So I'd be happy to expand on this and some other issues that I've noted down about your presentation and paper, but we can keep that for later discussions.
Thank you, Pranesh. Jaideep, would you like to add to that?
Sure. Firstly, thanks for having me, and lovely to hear your views as well as the views of Natalie and Pranesh. I would largely echo a lot of what has been said. I take off from one or two spring points of what Pranesh said about the default setting as well as balancing. I think as of now, largely we are in a openness by default setting in terms of judgments and orders being public. Also, court records can be accessed by third parties after a case is decided as a matter of right in many courts. So, for example, in the Delhi courts, after the decree stage, any third party can access all the case papers as a matter of right. However, prior to the decree stage, they have to show sufficient reason. Um, that kind of accords with the way other public records are also treated, especially after the Right to Information Act. that there is the right to the public information subject to exceptions. The RTI Act also has an exception for privacy of the individual. So I think really the heart of the matter is how do we put the balancing framework in place, given this initial framework that we have of openness by default, subject to legitimate privacy interests. Do we do a case-to-case methodology, or do we do a blanket rule that certain kinds of information, whenever it appears in court records, should always be redacted, for instance? As of now, we have a case-to-case framework in India. For instance, a party can apply to say that there is a privacy interest in certain aspects of information, and courts have sometimes accepted that and said that the name of a certain party should not be disclosed, or certain other information should not be disclosed. We also have some blanket rules like regarding sexual harassment victims. They have a privacy interest by default. But whether we should have a new body or the current ad hoc system is working, I think that is really where we need to delve in deeper. And possibly there are people who may not have the wherewithal to approach the court for their privacy interest, or um, uh, to have that information specifically redacted. They would be benefited by a blanket rule. On the other hand, whether a blanket rule would kind of um, not do justice in each individual case, as opposed to a court applying its discretion. So I think that's where we need to delve in deeper. I don't have an answer, but I think that's where it's very interesting to go deeper.
So, given that currently in India only judgments are made public and other court records like pleadings are not by default in the open domain, what what are the kinds of harms or the potential for misuse which is there from the online available court records, and is there really a reason to worry? Jaideep, if you could, explain to me, like, is there really a reason to worry about such private information contained in judgments?
Right. I think as of now, you do have, of course, a lot of the courts publishing not just judgments but orders. And personally, I'm in favor of that publication of the daily orders of a case. As Pranesh said, it helps the litigants track the progress of their case, as opposed to having to be entirely reliant on their counsel as they were in the past. But obviously, with that entire mass of data being available for scraping, etc., it's possible for people to draw insights into maybe the personal behaviors of an individual based on their past case history. So obviously that is a concern from a privacy aspect. Most individuals, unless it's a matter dear to them, may not want to expend the resources to apply to the court and get the information redacted or pulled down from the public record. So there, whether we need a rule as to whether certain kinds of information should be removed, or as Pranesh said, the time aspect, um, whether certain kinds of information after expiry of a certain amount of time it should be removed, that becomes a question. But one thing that I don't think would go away is the judgments would always be there because of the precedential value. They always have to be there from a time perspective. But I mean, it is at the liberty of a party to make an application to the court to have certain information not be displayed in the public record. So maybe empirically, it would be interesting to explore whether people are facing this difficulty that despite their efforts, they are not able to get it done, or some people are facing the uh, that problem and are not able to approach the court. I think there we would have to see where the real problem is and what is the ground reality of people facing this issue. I think where people have approached the court, some courts like the Delhi High Court have in fact taken a pro-privacy view in certain matters. So yeah, that's what I have to say. I'd be interested to hear from others as well.
Natalie, could you tell us about your experience in the UK? Have information from court records been misused to inflict any kind of harm?
I think we don't, well, there are a number of things that I thought on listening to Jaideep. I think, so there are certainly good examples from the US where court records have been used to inflict harm on individuals. So, for example, you have an example where a private publisher of court documents has made its entire database available to the Immigration and Customs Enforcement Agency. There are also examples of the way in which the private information contained within court records has been used to create kind of credit profiles. One thing that I would say about any system that relies on individual litigants applying to courts to have their information redacted is always going to benefit more sophisticated litigants and actually make it more difficult for people who are more vulnerable. And that's a problem. One overarching thought that I had is whether we manage the risks, and I think that that's a really good point that Jaideep made about we do need better empirical evidence to understand which of the risks associated with open data are real and material and which are theoretical and illusory. So, for example, a lot of the debate in the UK has centred on the use of predictive analytics to predict the outcomes of cases and whether that might lead to a fundamental issues around access to justice in terms of enabling the doxing of individual judges or distorting litigation patterns. But we really don't know enough about whether those techniques can even be applied like feasibly and reliably to achieve those outcomes. So there's a desperate need for that. I think it's interesting, when I was looking at the work for the UK Court Service and being involved in a number of these debates internationally, we've all focused very heavily on how do we regulate data, how do we regulate the access to data. But there is another approach whereby instead of regulate, you could actually legislate against the harms. So in France, for example, they decided that one of the things that really was a threat was judicial analytics. And so now anyone trying to do analytics using court records, that's punishable by a fine and up to 5 years in prison. And so I do think there's a question as to whether we're taking the right approach, because openness of court records is so important for all the reasons that the other panelists and you have set out around understanding the law, precedential value, being able to understand what happens in court. One thing to think about. And the other thing that I thought was really interesting in your paper is this concept of the public interest, and that's something that we're really grappling with in England and Wales, like who gets to decide what the public interest is. So I think that's something that's really important to think about, because depending on who you speak to, some people say, well, the public interest is in a strong economy. So if you can use court data to prime the law tech sector or develop new products, then that's in the public interest, and we should absolutely make data available for those purposes. Whereas others would say, oh no, that's not quite right. The way we're approaching it at present is with this idea of the public interest in the equal administration of justice. So we permit uses of data that support equal access to the justice system and deny those that don't. I think the other thing to really think about here is, the public mandate. Like, how do we understand what the public, and by this I mean, and there are various different publics involved in the court system, how do we understand what they think and what they feel about their data being used in different ways by different types of actors? Because fundamentally, one of the risks that I thought it was really great that you put in your presentation is, well, how do we make sure that the policies that we have around making data available don't deter certain types of people from bringing their problems to the justice system in the first place? How do we make sure that greater openness doesn't deter certain types of people from bringing their cases to the system in the first place? So I think any body that's established to develop regulation needs to have within it a really good function and mechanism for getting a better understanding of what the public, justice system users, people who represent stakeholders in the justice system think and feel about these issues. So that's what I would say.
So one of the major concerns which has been voiced is, as we were referring to, data scrapping and data mining, which might facilitate unauthorized bulk access to these court records. And then this can be repackaged and then distributed for commercial gain. So on the other hand, as you said, bulk statistics are also important to highlight systemic issues which need reform in the judicial system. So maybe Pranesh, you can tell us about how do we approach this issue of regulating bulk access to court records to ensure that it's only used for legitimate purposes?
For me, this framing itself is problematic because it, in a sense, for instance, assumes that bulk access for commercial gain is illegitimate, or say the other kinds of examples that were raised, using court records for immigration purposes, using it to create credit profiles, that these are illegitimate. For me, that itself is questionable. Are these illegitimate? Why ought people not be able to create these kinds of things? And if they are to be made illegitimate, is a general privacy or data protection bar the right way to approach it? Or would it be better to have more specific restrictions, say? So if, legislating against the harm rather than legislating in terms of privacy. So, and I would take a very different example. So, for example, if the harm that you foresee, if India, in its battle, the Indian state's battle against Naxalites and ultra-left Maoist organizations, there were some truths to be reached, and but these people are processed. These former Naxalites are processed through the court system, but they, because of this truth, they're given a second chance with the reduced sentences. But because that tag and the availability of their data online through an easy search for their name always keeps hampering them in terms of discrimination, is the right way to approach it through not being that court record not showing up, that judgment order, etc., not showing up when you search for their name? Or is it to actually pass a law against discrimination based on their past status as say a terrorist, right? So what is the right approach? For me, it's not very clear. It is about a question of values, and that's kind of what I want to kind of emphasize here, that on issues such as this, there is no one, there is no agreement in terms of values. There is no agreement, I think, amongst people generally, that commercial gain out of public data is a bad idea, because that, for instance, is what openness advocates, who, for instance, push for Creative Commons license data, which is CC BY, okay, who say that non-commercial usage should not be a restriction, that even commercial usage of public data should be allowed. Okay, they might actually see a problem if you assume rather than demonstrate that commercial gain is a bad thing to get from public data of a kind that is made public for a variety of reasons, and to presume that certain kinds of uses are ipso facto illegitimate, and so on. So one, there's the question of values, and even if we agree on the question of values, even if we agree that certain kinds of uses are bad or should not be allowed to happen, the question still remains open as to how do we tackle it? Do we tackle it through restricting access to the data, or restricting that specific kind of use that the data is put to? So restricting, say, discrimination and passing a law against discrimination. So two things two levels of answers, in a sense, that problem.
I think, sorry if I may, I think that's such a sensible and important point. And what you're talking about here is actually broader policy questions, which is why it's problematic to leave these discussions and decisions up to individual judiciary, because their role is not to establish policy. Their role is to implement the policy that's set out by the state. And so actually focusing all of the attention on resource in how do we strengthen the judiciary's ability to set guidance around this, actually what we're thinking about here is more what's the broader policy space in which we're operating? What does good look like?
Yeah. May I make a point?
Yes,
that carries
sure.
forward from that. So one of the ideas you emphasized in your slides was that this is something that derives from judicial independence, that regulation of judicial data by an independent body derives from judicial independence. I'm not really sure about that as the source, but administratively, each high court is independent. Okay, and so for me, that it derives not from the abstract notion of judicial independence, because I think one could very well imagine Parliament legislating policy for the judiciary, with regard to data privacy. That's not an encroachment into judicial independence, in my opinion. But because of the administrative independence that high courts have, I have difficulty imagining a single body unless all high courts somehow come together on this issue in India. And for me, it's valuable to have uniformity, some amount of uniformity, at least in terms of guidelines and guidance to judges in terms of what ought to be private, and when they're faced with individual cases where they have to stray from the guidelines, what they ought to be looking for, and how much leeway they have, and so on. So for me, I wouldn't think that one ought to completely remove judges from these decisions, but most of this is not actually something for judges to say on a case-by-case basis. Most of this is stuff to be embedded into processes, into the software, to be embedded into how into the digitization process, and so on, as you lay out very well in your paper. And so, but there might be some residuary amount of flexibility that needs to be provided to judges. But most of it is just policy matter that I'm not really sure it's really a judicial matter, and I don't really see judicial independence as the source for that in a sense.
Shaideep, would you like to add something to this?
Yeah, I think both are very sensible points. I think right now it goes court by court, because as Pranesh says, each court lays down the administrative rules. For example, in the Delhi High Court, a third party looking to obtain case papers before a case is decided has to show sufficient reason. So obviously each judge would interpret sufficient reason differently as to what is the interest of that third party compared to the privacy interests of the parties in the case. Perhaps we would be benefited by a provision laying out the balancing test to be applied, like there is in the Right to Information Act. So it is still maybe decided case to case, but there is
Oh no, it's such a good point. He'll be back.
He'll be back soon, yeah.
I have a question actually for Pranesh as well. I am looking at the slides. One of the things that struck me was about the negatives, the risks around digitization, was this lack of control that putting records online. Now, is that inevitable? What are the tech solutions that could be used to kind of build friction into the system? Because presumably, so for example, access to our case system, you have to have a user ID and a login to be able to do that, and that in some way can act against like bulk scraping. But I wondered, to what extent is making this data available in digital format online inevitably going to lead to a loss of control, or are there technical solutions that could be put in place to address some of the concerns that the paper identified?
Should JP finish his point and then I respond to this?
Yes, that
Sorry about that.
Yeah,
No,
we can continue from where you left.
I was just wondering whether there should be maybe the balancing test should be codified and then it is left to discretion. But I think there is also value in having certain kinds of data maybe protected from public disclosure as a matter of default. Because as Natalie said, it's not everyone is always empowered to approach the court, may not have the time, may not have the resources, may not be able to follow through on an application, which a simple application may take months to be decided, and you have to engage counsel to argue the application, etc. So there may be some value in having certain defaults, and also a balancing test, and then the judge can then apply that.
Thank you, Jaideep. Pranesh, if we could hear from you about Natalie's question.
Sure. So I think there are two levels of answers again. So one, I think inevitably in this, to be able to answer this question, you again have to come back to the question of what harms are, right? When you're thinking in terms of what tech solutions there can be and restrictions there can be on harms. So in very many cases, what people are trying to avoid is their identity itself being linked to a particular order or case. So that I was involved in this case itself is something you want avoided, whether it is as a person who who's a complainant, whether it is as a witness, whether it is as say a child in a child custody case, whether it is in very many different ways your involvement in the judicial process itself you might want to obscure. Now, given whether that, to what extent that can happen, is not something really, in my opinion, most of that is not really a tech related issue, because it would either apply to everyone, even those who actually go to to an office and want to pull up records, or not. But in terms of how you can apply tech solutions, again, it comes back to a question of values, because if you do believe in open courts, and if you do believe that that these things should be easily accessible, then you won't prevent scraping. So one of my, a friend of mine runs what I would say is India's largest judgments repository called Indian Qanun, and he's had a lot of problems over the years with different courts trying to prevent the scraping that he does. And I'm not sure it's legitimate, because one ought to have access to judicial to orders and to judgments and so on. This is public information at the end of the day, and this so putting in place, say, CAPTCHAs to prevent mass downloading, to prevent scraping, it depends. If you put in place, if you're redacting things at the source, then it's fine. I think through a judicial process, through careful application of policy, you're removing certain names. But if you're keeping that information, but want to prevent third parties who are operating from getting access to that information. I personally don't think that's a wise option. Any kind of tech restriction that you put in place ought to be put in place at the source itself. And I personally would be against, I'm not against gradated access to data. Generally, as someone who supports openness, I think having gradated access is compatible. But when it comes to the core of judicial data, okay, when it comes to orders, judgments, even say pleadings, things which aren't public right now in India, affidavits and so on, I think these things, putting in place restrictions to them in terms of the scale, right? In terms of mass downloading versus individual downloading, research use versus other kinds. I think that itself is a problem. It's not something I can see working out feasibly. One can, of course, say those who do download this information are still bound by privacy law and regulations and still have to comply with any kind of request from the public in case something has slipped through the cracks at the source and they aren't exempt from it as third parties. One can, that I think would be legitimate, but most of the other kinds of gradated access requirements for this, I don't think would be justified, given the very strong need or the very strong justification of open justice and open courts as a principle. That I think is it will take a lot to negate that in terms of privacy needs.
The classic example, I suppose, that's often raised is, I don't know how aware you are of the Globe 24-hour case, which was a case in Canada. So essentially, what happened was a company from Europe scraped the entire case law repository, Canly, and then created its own repository and basically charged people who wanted their judgments taken down a fee. So it was essentially using the information contained within those court records for extortion. But in a way, that's something where it's, well, you can very clearly create a legal framework that makes it unlawful to use case law data to extort money from people. That doesn't necessarily mean that you have to then ban and I guess this is the point that Jaideep was making before. It's about how do we get a better understanding of what the real risks and harms are, and then can we create a framework that tackles those whilst preserving the fundamental importance of open justice.
So one way of actually looking at the current harms of measuring that with whatever data is currently available publicly is to actually go to people such as, say, Sushant Sinha, who runs Indian Qanun, or other such open legal search engines, and to ask them what kinds of requests they get. In addition to actually filing RTI requests, say with different courts and court registries and so on, instead of just looking at it from the official sources, one can look at unofficial sources as well and see what kinds of requests they get from people to see what people are most feel that they are harmed by and want to get removed. But there's a big caveat here, which is, for me, it's not very obvious that whenever someone feels that, or whenever a large constituency, even not just an individual, feels that something is harmful, that necessarily means that the court or the government or whichever entity we are tasking with this ought to say that it ought to be made unavailable, because there is a strong countervailing interest of open courts and open judicial processes. So one may assert that I'm getting discriminated against because of this. One may assert that if this information is available, people will come and extort me because they know how much wealth I have and so on, and we live in a dangerous country. One can imagine various kinds of harms, and the kinds of harms we we can imagine aren't really limited. And I'm sure there are actual instances of many of these happening as well. Of property builders looking at court records to see where to invest, of all kinds of things one can imagine and one can paint and say they're harmful. But that again comes down to a question of values, and that again comes down to a question of whether you want to protect it through obscurity, through privacy, or by actually legislating against that specific kind of harm.
So just to follow up on commercial gains from court records and whether they are good or bad, legitimate or not, how does the concept of consent tie into this? Because judicial participants, when they provide information into the system, they are not consenting to the decontextual use of their personal information. So if you could talk about that a little. Yeah, anyone can go. Jaideep, Pranesh, anyone.
I'll make a very quick point. I think it's unreasonable. There's a lot of discussion nowadays, especially in Indian civil society groups, who make a point that, for instance, and I'm quoting from a recent tweet by a civil society organization, that there exist situations where your data can be processed without consent by the government, and thus prioritizing, they say, interests of the state over citizens. For me, that is kind of meaningless, because by the very fact of living in a nation state, living in society, you are agreeing necessarily to not doing everything through a consent-based framework. There can be other kinds of framework, and necessarily have to be other kinds of frameworks in society for access to data. Now, and there are very many practical reasons as well, apart from just the idea of a social contract. There are very many practical reasons, such as the state has far more power over you, okay, than you have against the state as a citizen. So the question of having informed, meaningful, coercion-less consent to anything becomes far less useful, because when it comes to the state, there always is some amount of coercion. So there have to be other kinds of ways that you protect citizens, and not just rely solely on the idea of consent. And that is, again, one of the reasons why under the GDPR, there are 6 different legal bases, for processing of data, of personal data, not just consent, right? And again, similarly, under the proposed data protection bill in India as well. So for me, saying that there is no consent does not by itself show that this is actually wrong or illegitimate. Okay, it raises the question of, okay, then how do we actually contextualize it in terms of harm? How do we actually how do we protect the people in the absence of consent, and so on? And that in itself doesn't really tell me much about whether there's harm actually happening or not.
I agree with much of what Pranesh has said. Like, I think consent really does. One of the big challenges under GDPR, particularly rules around automated decision making by the state, is that to the extent that our frameworks rely on consent or opt-outs as a way of balancing rights, when you're talking about the state as a monopoly provider of services, as a monopoly, it's just not. It just doesn't make sense. Like, you can't if you want to access certain services, if, for example, welfare benefits or others that are provided, but you have to provide your information. There's no way for you to manage like how the state uses your data through that basis. One example that I think is really interesting is looking at some of the arrangements we've put in place around data for health research in the UK. So essentially, there was big public concern about data about about individuals where they haven't consented to participate in research being used for research purposes, but we know that there is a huge kind of public value in you being able to access that data even when the basis isn't consent, because we need to develop new treatments. And the way that we've approached that is by setting up a number of really strong ethical committees that take a really close, that are populated by experts, that take a really close look at any applications from researchers who wish to access data and where the patient hasn't consented to be part of a study. And so I think that's quite an interesting model for thinking through kind of rules around how we make aggregate data and how we balance again the rights of the individual around privacy with other societal rights, such as the right to improve health or the right to be able to other interests around access to improving public health.
Jaideep, what do you think about the concept of consent in the judicial context, or how do the other data protection principles of data minimization or data retention or the other general principles of data protection, how do they apply to the judicial context, whether they can be applied as is or whether certain modifications need to be made?
Just one narrow point. So unfortunately, there is an implicit consent when somebody files a case. Of course, that only goes if you're the plaintiff or the petitioner, because you are implicitly consenting to the rules of the court on what data will be public and your rights to possibly have that redacted or have that not made public. Of course, as a defendant or a respondent, you are kind of forced to participate in the process. As Pranesh said, that possibly the only consent is you're living in that jurisdiction. But yes, those, I think the closest we have to consent is the implicit consent of being bound by the rules of that court. And of course, there is a right to have the data not made public, but one has to fight it out through the ad hoc process that we discussed.
So if we were to proceed to form a privacy policy for the Indian judiciary, I know there's a privacy policy in place for the Supreme Court of United Kingdom, but if we were to proceed to make a privacy policy for the Indian judiciary or have these access policies or guidelines, whatever we may choose to call them, what are some of the factors which will determine the level of access granted or restrictions or conditions on use of the data gained through such access? What are those criteria or factors which can be employed to formulate such a policy? We can start with Jaideep.
Yeah, again, another limited point is I would say they should be quite similar to any other public authority, because courts are not the only ones who deal with public records and public documents. And the new privacy framework, whatever it is likely to include, of course, government bodies within its purview as well. How those exceptions will work for the government's access to data, etc., is separate. But possibly the accountability and treatment of data may be similar to other public bodies. Of course, the legislature does not deal much with personal data, but the executive wings of government do deal with people's, of course, very personal affairs, their land, their property, water, electricity. All kinds of personal documents are in the custody of public authorities. So, I haven't thought in detail about this question, but I would say, as a thumb rule, it should be similar to how other public authorities are made accountable.
I think
Yeah, Natalie, you can continue. Yeah.
Sorry. No, I think it's actually, again, it's a more kind of normative question. Under data protection law in the UK, if governments want to process data, it has to be linked to their public task. And so that leads us back to a question of what is it that the justice system exists to provide. So the court service in England and Wales has within its public task, its established purpose around administering a fair and effective court system, supporting the effective administration of justice and promoting access to justice. And so I think thinking about what uses of data are likely to promote access to justice, equal access to justice, I would add, what uses of data are likely to support the administration of justice. And that could include third-party access to develop new sort of tools that help people to navigate the justice system. But that importantly would act as a way of filtering out any kind of uses of that data which actually might undermine those core principles that the justice system exists to provide. So anything that looks like it's going to increase inequalities of arms, which we know exist within all of our justice systems globally, I think those could be fairly excluded from the remit of that policy. But I think in order really to develop these principles well, it does need to come back to having that better empirical understanding of the harms of different types of uses. And again, it's one thing to have those as a general kind of overarching principle, but then it's another thing to think about, is the best way to balance like risks and harms with the overriding interest in open justice, to think about this in regulating data, or is it about tackling those harms? One other question I had looking at the model was, how do we, if it is to be a judicial regulator or a judicial group that's developing the privacy policy, how do we help them to have the knowledge and understanding both of what other sources of data already exist and also the things that sort of actors in the space are really thinking about? I think there's a huge amount of upskilling that needs to be done. That's not an indictment of judges. It's not their job to really look at the wider data landscape and to understand like developments in technology, because I think some of the anonymization was always held to be, or pseudo-anonymization was always held to be like a gold standard of protecting identity. But we know through developments in technology that things like jigsaw re-identification are getting better all the time. And so will anonymization of individual documents actually serve these different ends? I'm not sure. So I think it's about, the principles need to be, what is the justice system there to secure and provide, and any information governance needs to be linked to those overarching strategic goals of the justice system. And then beyond that, thinking through what are the risks and harms that we want to prevent with that policy, and are they best prevented through a policy that focuses on data, or are they best prevented by other types of routes to regulating those harms?
Thank you, Natalie. Pranesh, would you like to add to that?
I'm not really sure what I can add. I think your paper and what the other panelists just said sums it up perfectly. Perhaps I could just point out that the exemption under the proposed PDP bill is not an absolute exemption, but for instance, the requirements for specific, clear, and lawful purpose still applies, and the requirements for data security, including de-identification when necessary, including preventing misuse of personal data, and using data security for that, including things like encryption and so on. Those still apply. How they will be applied is an open question. At any rate, I actually think the kind of blanket exemption that we have, or almost blanket exemption that we have, is not quite warranted. I think a more limited exemption under data protection regulations and law would be a better way to go about it, and to actually in advance think through what this would mean. So to essentially do what you have done, right, in terms of mapping out judicial processes, mapping out different kinds of data that the judiciary processes, and to see how these principles, for instance, not the idea of privacy, how those would apply, but also more specifically how specific data protection principles would apply to different kinds in different scenarios. And so I think that would need to be done. Who would do it? I'm not really sure, given the complexity in terms of the area, given what is being proposed in the data protection law right now, given how administratively different courts, different high courts are their own fiefdoms, given all these things, how this would really, who should do it, whether it should just individually every high court should go ahead and do it. I don't know what the right kind of approach is, very frankly, but it is something that needs to be done. And I think your careful paper is a step in the or papers actually are a step in the right direction. Just one nitpick on the issue of anonymization. Many of the harms that actually will arise from, say, judgments being public would come from more careful text mining. So they wouldn't come really from just the names of the cases, which are easy to get, but more from the context, more from, say, a particular witness being listed or whatever, saying that this person was involved in, and so on. And if those kinds of things are blanked out, are redacted at the source, then reconstruction of that becomes much harder. So it's not quite comparable, I think, to a situation where there are multiple large databases, all of which to different degrees are, in a sense, anonymized. But by combining different databases and by combining things which are, and by figuring out patterns and saying that this record in this database actually matches up with this record in this database, because 3 out of 5 fields actually match up. And so by combining that with another database which is not anonymized, we can figure out who the actual person is with a good deal of certainty, say above 80% or something of that sort. Instead of that kind of analysis, that kind of de-anonymization, I don't think is as much of a concern when it comes to at least standard judicial documents, which are text heavy, which are not just plain databases, and which don't lend themselves, I feel at least, as easily to this kind of analysis. So I wouldn't go out on a limb and say it's impossible, but I would just say that much of the analysis on de-anonymization and the literature on de-anonymization deals with very different kind of data sets, and I would be a bit wary in directly applying that literature to judicial data.
Thank you, Pranesh. And with that, I have come to the end of the questions that I have for you, but there are several questions from our audience that we can take up now. And the first question is for Jaideep. Our audience asks, has online access to records changed the kind of information that lawyers or litigants submit to the courts, in your experience? Or is the digital divide still too vast to have any effect on this?
I think it would for those classes of litigants that know the implication of the cases that they file or even their responses in the cases. For instance, someone may be wary of filing a small stakes case for fear of being branded that they're litigious or their personal details on the facts of that case coming out. So someone would have to take a kind of pros and cons approach on their stance in a case, knowing that everything they say may eventually be public. Somebody's petty airline dispute or somebody's land dispute, it's largely their private affair, but eventually it's going to go up on Indian Qanun. So, I mean, the world can then read about it. So I think people would be aware of that trade-off. Personally, I have also thought about that trade-off when faced with some, some situations against, say, an airline company, or whether to file a consumer case. It may not be worth the trade-off. So I think that's something people would think about. But of course, where the stakes are high, of course, in a criminal case, there's almost the discussion doesn't arise. You would have to kind of apply to the court to redact what you would want redacted. In a civil case, if the stakes are high enough, that one has to kind of compromise that aspect, or has to try their luck with court and have that information not made public.
Thank you, Shailesh. Would anybody like to add to that? Or
I have seen in our jurisdiction some articles published primarily by barristers who work on commercial litigation or litigation involving really high net worth individuals, who've argued that the principle of open courts actually acts as a deterrent to high net worth individuals bringing their cases towards the courts. But I think, it's such a minority interest, because in the vast majority of cases, you're not talking about people who are able to buy their way out of certain dispute resolution mechanisms and into other forms of more private dispute resolution, so arbitration. One of the things that we've seen happening in the UK is we've had roughly about 10 years of austerity cuts to our court service. And there's an increasing interest by the state in promoting different models of alternative dispute resolution or dispute resolution outside the courts. And whether or not those are held to the standards that exist around openness in courts is I think it's still up for debate. So I think all of which I would say is in our experience, it's only really the sort of experienced, wealthy litigants who would think more carefully about what information they put before the court. I don't think it's something that, certainly for the majority of litigants that the foundation I work for supports, it wouldn't enter their thinking, I wouldn't have thought.
we have another question. It says, how would data regulation address privacy issues in live streamed hearings? Would it be necessary to allow them in a narrower set of circumstances than is currently in place for courtrooms? Maybe Pranesh, you could take that up.
No, actually, I think one of the other two panelists would be better at that than I, very frankly. And you have in your paper very good discussion of, I'm so sorry, of Indian precedents and cases on in-camera trials, and not just India, UK cases that we have used as well in India. And so that, I think, answers it better than what I could. But yes, it does increase the need to confront the question far more often than, say, just a plain courtroom setting would. The one thing I would add is, again, that these are value questions. So and there are no clear answers always. I'll cite two different examples. So one, in countries like Finland, Sweden, and Norway, tax data, which in very many other countries would be considered very private information. Indeed, the former president of the United States of America decided not to make public his tax data for a variety of reasons. And most would, in many other parts of the world, would say this is private unless there are compelling reasons to make it public. Well, it's the other way around in those Nordic countries where tax data is public. And there's been a lot of debate about how to handle this shift from where you had to go to municipal office to take a look at someone else's, your fellow citizens or your lawmakers' tax data, versus all of it being available online. And so it's not to me something to be assumed that that just because in the rest of the world something is private or public ought to mean that in India we follow the same principle, same idea. It's something, in my opinion, this shift allows us to look at it from, as we said earlier, from first principles. And while I don't have much sympathy for high net worth individuals and in their quest for privacy, one could also argue that one could say that so this kind of takes me back to the previous question. If I could quickly throw in some comments on that, which is, one could, I think it's a very interesting approach to say for consumer courts we set one standard, for criminal cases we set a different standard, for matrimony and custody cases we set a different standard, and to segregate it by what kind of judicial function is being performed. And consumer courts say most of the data, actually you don't need to know who the individual person is in most situations, and that doesn't affect, there's also very little precedential value in consumer disputes most of the time, and so various kinds of reasoning that we apply for open courts don't apply as much, and so we could apply the idea of privacy much more strongly there, one could argue, and say for criminal justice, on the other hand, it's the other way around. But the counter argument to that would be that if and to bolster my point that it's a question of values and not something inherent in the system, if your objective of a criminal justice system is reparative, and it's not just it's supposed to be a punitive system, then you might actually decide to say we don't need to know as much about who committed these crimes, or at least after they've done their time, that we actually remove these records, put them in, declassify them, say, as judicial records, keep them as archival records, okay, and have a different kind of system for access to archival records for, say, research purposes and so on, that they won't be available anymore, and through regular search engines, and that this be made available, be made the situation not just for at the source, but that this regulation be made applicable to all third-party providers as well of judicial data. So I can very well imagine a system like that, but whether to have this kind of system, which might be feasible, is a question of values. Okay, why is the criminal justice system there? What are we trying to achieve through it? Are we more, where do we fall in terms of our ideas of how progressive the system ought to be, and so on?
Thank you, Pranesh. The next question is for Dr. Natalie. In what circumstances have the United Kingdom and countries in the European Union determined that otherwise sensitive information is of public interest? For example, in the case of public officials, there might be some kind of sensitive information about them, but because they are public officials, the court has erred in favor of disclosing such information.
I don't know how we've had a number of really big debates in the UK around the use and application of super injunctions to protect privacy. And it's not my area of expertise, but there's certainly, if this is of interest, I'm more than happy to link the various reports that people have had. I think in other areas, so generally this tends to come up most in health, actually, so things like wanting to use health data to develop new products or treatments, or to understand the impact of particular health treatments on downstream consequences. So one particular example which had to be dealt with was a study. They wanted to look at the consequences of late-term abortions for women who'd undergone them in the UK. Now, that's obviously extremely sensitive information, and the numbers of those procedures that take place are so low that there were concerns that even anonymizing that information, and it would be possible to identify those women from the basis of the hospitals that they'd been to. And the way that they approached that was by applying the sort of public interest test in the promotion of health. And that was considered by a committee of experts, both in research and in the treatment of and in gynecological medicine to arrive at a decision. But it tends to be thinking about, it's the notion of the public interest does a lot of work in this space, which is why it's so important to be able to narrow that, because I think public interest is a really baggy concept actually, and it means different things to different people depending on your normative position. And so actually I think moving towards a more kind of detailed understanding of what that actually means is something that's really important when we're thinking about how we apply that to our justice system.
Thank you. The next question is, how do we go about framing rules for redaction of data? In some jurisdiction, the obligation to identify and remove parties' personal detail rests on the lawyers. Following up is whether allowing this approach will lead to a scenario where the issue of redacting itself becomes contentious and leads to multiple rounds of litigation. Jaideep, would you like to respond to that?
I think the RTI Act also has a principle on this. I think Section 10 is on severability. So the Act has taken the approach that it's not that either you disclose a record or you don't disclose a record. There is a possibility of redacting some information from a record which has an impact on the privacy interest of the individual. But yes, of course, that is it. As soon as there is balancing, there is subjectivity. So that will definitely lead to rounds of litigation. It may not necessarily have to be done by judges. It could maybe be done at the registrar level, or it could be done by maybe quasi-judicial officers, or even by judges. Because I think as of now, if a party makes an application for some information in the case not to be made public, it's done by the judge hearing the case. It's decided by the judge hearing the case. But yes, there is, I think, inherent subjectivity in that decision.
I think that brings us to the end of our session today. If any of you would like to make any closing remarks or anything at all.
Only to say we've focused a lot here, understandably, on the risks involved in openness and data sharing, and that's right and appropriate. But I think it's also, speaking as a researcher, it's also incumbent on those people who really care about open justice and who care about the range of things that it's meant to provide, to do more to kind of illustrate the risks and the costs incurred in not making data available. It's something that's, so when we were developing our work for the court service, one of the things we looked really hard for was better evidence about the impact of making more data on the justice system available on improving access to justice. And we really found it really difficult to move beyond rhetoric in that space. And so I think the more that we can do as a community to gather better evidence on both sides of the debate, I think the better able we will be to decide principles that really work for people. And just to say thank you so much for having us here today, and thank you for your amazing, careful work. I'll definitely be taking it back to the UK and sharing it with people who are working on this. So really very grateful.
I think
Thank you so much.
to see some jurisdiction where the court records are not public, and then kind of see how they're getting along. That might be an interesting case study. Yeah, thanks for hosting us.
And I just add that I would really urge people to take a look at the papers that Dutch has produced and to provide feedback to it, and to engage with this very important issue, because now, especially post-pandemic, especially with how much online hearings make available publicly, especially with these kinds of issues, what you're talking about is more pertinent than ever. And so please to engage with this issue and make your valuable inputs available to everyone. So.
Thank you to our panelists for joining us today and sharing your experiences and insights on this topic. And thank you for all the feedback on our paper. You can access our paper on our website, and do follow us on social media as well for regular updates. And have a great evening. Thank you.